Hello everyone and welcome to this video tutorial in which I'm going to be doing a really quick introduction to law and the English legal system. And in this video we're going to be looking at where our laws come from and how we define what a law is. And in so doing we'll be distinguishing law from morality, because sometimes people confuse law and morality and they're two very distinct things. And I'll also be giving a quick introduction to some of the key differences between criminal and civil law. So if you're just starting out with A-level law, hopefully this video will be really useful to you. And equally, if you're doing some revision for your exams, hopefully this will be a nice refresher and go through some of the key terminology that you should already know. So let's start by considering where our laws actually originate from and what different types of law that we have. And this particular diagram here hopefully will be helpful to you because it shows some of the different types of law that you study on A-level law and shows you how those types of law fit in to the bigger picture. So to begin with then, when we're talking about laws, we can differentiate between international law, which is concerned with disputes between nations, and we can distinguish that from national law, which is the law which applies within a particular country. So international law you may study if you're looking at human rights law, and you may study that on A-level law. But primarily we're going to concentrate today on national law, and this is the law which applies within a country. And there are two main types of national law that we can look at. There's public law, which involves the state or the government, and there's private law or civil law, which involves disputes between private individuals. So public law, the main one I'm sure you'll all have heard of at least, is criminal law. So criminal law is a type of public national law, and this involves the state because it's the prosecution in the name of the Crown who are prosecuting defendants who are accused of criminal offences. There are other types of public law such as administrative or constitutional law, but you'd study them on a degree level law course, not on A-level law. So the main one for us is criminal. And you can see here from the diagram that you would expect the terminology and the different rules around this type of law to be different from private law because they're two very different, very distinct types of law. And you'd be right, there are some really key differences between public and private law. And at the end of this video tutorial, I'll show you some of those key differences to make sure you're familiar with those. In terms of private law, we've got contract law, and I've got lots of videos on my channel on that. We've got tort law. Again, I've got lots of videos on this channel for tort. And we've also got family and company law. Now again, family and company law you would study on a law degree, but not at A-level. So the main ones for us are criminal, contract and tort. And if you're studying those particular areas, do check out some of the other videos on my channel where I go through the different criminal offences and the different elements of a contract and the different torts that you need to know. So hopefully that's a nice outline of where our laws actually originate from. And it'd be useful at this point just to make sure that we know what a law actually is. So let's consider that on the next slide. So let's start by considering a definition of law. Now I'm sure you've all got an idea of what law is, but obviously as law students we need to be able to come up with a nice definition. So I've chosen two here, one by John Austin and one by John Salmond, but you'll be able to find lots of different definitions in your textbooks. Let's take a look at these. So Austin says, quote, that law is a command issued from a superior to an inferior and enforced by sanctions. So he's saying that the state is coming up with commands or rules that are enforced by sanctions against individuals. If we compare that to Salmond, Salmond says that law is the body of principles recognised and applied by the state in the administration of justice. And notably, Salmond has got justice in his definition there. But at its simplest level, we could say that law is a formal mechanism of social control, and it's a way that our actions are governed by a set of standards that we have to adhere to. And of course, laws are really important in protecting your rights as a citizen, to provide order, to establish standards, to maintain the status quo, and to help also resolve disputes and protect civil liberties as well, because we often tend to just focus and think about criminal law, but remember that civil law and private law also comes within our definition. When we're defining law, it's really important to distinguish law from morality, because they're two very different things, but people often get the two concepts confused. Whilst law is a set of formal rules enforced by the government, as we saw in our definitions on the previous slide, morality is a system of informal, self-regulated values and principles guiding individual conduct. And within your communities, I'm sure there are lots of moral rules or moral frameworks for how it's believed that people should behave. So as a suggestion here, it's quite useful when you're thinking about law and morality to have a go at this activity. So what I suggest you do is, in a second, pause this video and list as many incidents, events, acts that you can, and list them according to whether they are moral or immoral, according to your own values. And then, once you've got that list of moral and immoral acts, I want you to list them or label them according to whether they're legal or illegal. So I'm just going to give you a second to pause the video if you want to have a go at that activity. And if you have had a go at that activity now from the previous slide, hopefully you'll started to really see the differences between law and morality. Now, in terms of what you've labelled moral and immoral, that will differ greatly depending on your own values, perhaps your religious beliefs. But as an example, you might have put, for instance, adultery is immoral. But it's not illegal, it's not a crime. So there are real differences between laws and morals. So on this table here, you can see that I've tried to summarise the key differences between a law and morality. So with law, a law can be altered deliberately by legislation. So the government can change a law overnight if it wants to. So recently the government has decided that XL bullies are going to be a banned breed of dogs under the Dangerous Dogs Act. And that's going to change in January. And that law is being deliberately changed by an Act of Parliament. Even though obviously lots of people love XL bullies and it's not a moral issue, but it's being altered deliberately and it can happen sort of immediately. Morals, on the other hand, evolve slowly and they change according to the will of the people. So laws can be changed quite quickly. Morals can't so quickly be changed. And I'm sure you can think of lots of examples of things that were perhaps not acceptable when your grandparents were young that are acceptable now. But it's taken a long time for those views to change. It's not just let's create an Act of Parliament and it's suddenly different. Coming back to law, law makes certain behaviour obligatory with legal sanctions to enforce it. So we've got that legal sanction supporting the rule, whereas with morality it's voluntary and there might be consequences. So you might have friends and family very upset with you if you break sort of a moral code, but generally there isn't going to be an official sanction. I have put excommunication in brackets there because of course I'm aware that you might be excommunicated from your community if you do something against their moral rules. But generally, its effectiveness relies on the individual's sense of shame or guilt. So we tend to follow moral rules such as not lying, not cheating on people, because we have this sense of shame or this feeling of guilt, rather than there's a sanction, you're going to be put in prison if you don't follow that rule. Again, in terms of law, breaches of law will be ruled on by a formal legal system. So in other words, you'll go to court and you'll have judges and potentially a jury deciding on whether you've broken the law or not. Whereas with breaches of morality, they're not usually subject to formal adjudication. You're not, going to be summoned to court if you turned up late to meet your friend, or you didn't turn up to meet your friend when you said you would, or you broke a promise. They're not going to be subject to that formal adjudication. So I'm hoping that if you did the activity on the previous slide, you noted that lots of things that you thought were immoral are not illegal, and perhaps vice versa. So another example I could give you is that if you park on double yellow lines, that is illegal, that's a crime. But it's not actually immoral to park on double yellows, unless obviously you're blocking a hospital or something like that. There's nothing innately immoral about parking on two pieces of yellow paint, is what I mean. So there's a difference between law and morality, and it's really important when you start out in law that you realise the difference. Lots of things will be illegal that are not immoral, and vice versa. So I've got a quote here from Lord Chief Justice Coleridge from 1893, so it's a very old one, but it's interesting. And this Lord Chief Justice said, when he was thinking about law and morals, "It would not be correct to say that every moral obligation involves a legal duty, but every legal duty is founded on a moral obligation." So he was making the point here that a lot of our laws have come from our moral values. And you could think perhaps of murder, for instance, has come from the biblical "thou shalt not kill." So a lot of our sort of moral values have been reflected in the law, and that's what he's saying there. And I suppose that's why a lot of people get confused between laws and morals, because of a lot of our laws do come from morals. And we've got the point here that moral standards of a community are recognised as having a profound influence on how the law develops. And it's quite interesting when you look at big changes in the law, how they sort of reflect the morals of society. Of course, they're not always going to make everyone happy. But for example, in England and Wales, you could think about the Abortion Act 1967. This was the act that made abortion legal to prevent the mischief, it was a mischief rule case, the mischief of backstreet abortions. And there was sort of a move away, if you like, from sort of the religious belief that prohibited abortions. So it was reflecting a change in society's views. And you can see lots of that, of course, in the law in terms of civil partnerships. It didn't used to be possible, but of course they are now. As morals have changed, the law moves with it. But the law is often very slow to catch up. But nonetheless, morals of society do impact the laws that we have. If you remember back a couple of slides to when I gave you a couple of definitions of law, one of them from Salmond referred to justice. And again, lots of people believe that law is all about justice. And we've got a quote here from Sagar 1602, so an ancient one. And it said, "What may be more blessed than justice, whereby we refrain from all injuries and give unto each other that which to him appertaineth." And of course, justice should be the ultimate goal towards which the law should strive. But is it possible? Is it possible to always achieve justice? There's a really interesting quote from my hero, Lord Denning here, and when someone said to him, I thought this was a court of justice, he said, that is where you are sadly mistaken. This is not a court of justice, but a court of law. So Denning was recognising there that there are limitations on the legal system and on courts, and I think the general public believes that we should always achieve justice, but unfortunately it's not always possible. And that's what I think is being shown here in this quote from Denning. So I'd like to end this little introductory tutorial by just looking at some of the key differences between criminal and civil law. So if you recall at the start, we were looking at the different types of law and specifically national law, and the two types of national law were public and private. Criminal is a type of public law, civil law is a type of private law. And you need to be able to distinguish between them because you'll have to answer exam questions on criminal law and also on different types of civil law. And they're two very different systems of law that we have with different terminology. So I thought it was useful here just to make sure that you're aware of some of the key differences between these areas of law. And firstly, the role of the law is different. So in criminal law, we are concerned with the prosecution of defendants who've been accused of committing crimes against society. Whereas in civil law, we're dealing with disputes between private parties. Another key difference is who actually brings the action. So in a criminal case, it is the state or the Crown that brings the action against the defendant. And you can see in brackets here, I've put an example case name. So R is Latin, standing for Rex, because we have a king. So in Latin, king is Rex. So when you are being prosecuted as a defendant, technically it is the king against, and I've used Pitt here, so are the Crown against Pitt. So it is the state who brings the action. Whereas in a civil case, it is the claimant who brings the action. And you can see that difference in how the cases are written. So I've used an example here, Heard and Depp. So this was Amber Heard taking Johnny Depp to court there. So two individuals. So when you see a case name written, if it's R and a name, you know it's a criminal case. Whereas if it's two names like this one, you know it's going to be a civil case. The purpose of the action is also different. So in criminal law, we talked about justice on the preceding slides, but there are actually lots of aims of the criminal law. So obviously we're striving for justice. But also criminal law may act as a deterrence, so it might deter or put people off committing criminal offences. There's also an element of retribution in it. We've sort of moved away a bit from that aim of criminal law, retribution, but certainly in the old days it was an idea of an eye for an eye. Of course, Gandhi said an eye for an eye and we'd all be blind. Hopefully now maybe we're striving more towards rehabilitation. Reparation is paying back to society, and restitution might be compensating the victim in some way. So there are lots of nice aims that the criminal law is trying to achieve. But in civil law, the purpose of the action is to put the claimant back in the position as if the tort had not occurred. So if, for example, someone negligently crashes into my car and causes £200 worth of damage, I, the claimant, sue them for £200. The court gives me £200. I fix my car and the law says, fab, you're back in the position as if the tort had not occurred. So that is a very different aim to trying to achieve justice or deterring people or getting retribution. So very distinct purposes for these two different types of law. The courts are also different. So you need to make sure that you don't get the courts confused. And it's a bit challenging because you can see the Magistrates' Court appearing in both. The Court of Appeal appears in both, but of course there is a criminal division and a civil division, and the Supreme Court appears in both. But you'll notice that the Crown Court is just a criminal court, and we've got the High Court here in our civil court hierarchy. So our courts are different. Burden of proof means who has to prove the case. So in a criminal case, the Crown or the prosecution have to prove that the defendant is guilty. And remember, it's a fundamental principle of criminal law that our defendant is innocent until proven guilty. And it is the prosecution that must prove that. Whereas in a civil case, it is the claimant, i.e. the person who is bringing the case, who has to prove it. How much do they have to prove it? Well, that's the standard of proof. So another way of looking at this is how sure do we have to be? And in a criminal case, it is a very high standard of proof. We have to be sure that the defendant was guilty beyond reasonable doubt. So the jury has to be almost certain, if you like, that the defendant is guilty. However, in civil law, I suppose because it's less serious, we're not generally looking at a prison sentence, the standard of proof is lower. So the claimant has to prove their case on a balance of probabilities, which is slightly weird terminology, but it means more likely than not. So that is a lower standard of proof required. So it is harder to prove a criminal case than it is to prove a civil one. And in terms of the consequences of winning your case or finding the person guilty in criminal law, prison is our main or our most serious consequence. Incarceration, that's the most serious sentence that we have. Of course, there can be fines and community sentences as well, but we tend to think of prison as being the main consequence. Whereas with civil law, if the claimant is successful, they can claim damages, which is just another word for compensation. And remember that that remedy of damages is designed to put our claimant back in the position as if the tort had not occurred at all. Okay, so I hope that little quick introduction has helped you to clarify some of the key differences between these two main areas of law that you'll be studying in A-level law. Do remember that I've got lots of videos on my channel that you can look at if you want to look at different crimes and different types of civil law. I've got lots of contract and tort videos you can take a look at as well.